And welcome. My name is Kate Marand. I'm a program manager at the DC Department of Small and Local Business Development. Incredibly excited today to be hosting this webinar by Energy and Transport Services, LLC. They're going to tell you what it's all about, but it's all about green infrastructure and opportunities that are here in the district. And so I'm going to turn things over to Curtis White.
Well, a good Tuesday morning to everyone. I am Curtis White, as Kate said. It's a pleasure to be with you this morning to chat about the CBE Green back office services, contracting with DCSEU, and in the green economy. Of course, the first question is, you're probably asking, what does DCSEU stand for? That's the District of Columbia Sustainable Energy Utility, for those who are not acquainted with the organization in terms of what the acronym stands for. Before we start, I'm joined by three very august and esteemed colleagues here this morning. Darren Riley, Trinette Chandler, J.E. McNeil, who are part of the presentation. I have preliminary responsibility, and since they have covered everything, I'm going to get out of their way, but I have preliminary responsibility for handling the early stage introductions. But before we do that, let me just say that I want you to read that disclaimer well at the top of the screen. This webinar is a general discussion of contract principles only. It is not, and it should not be regarded as all-encompassing and conveying legal advice that is applicable to any contract that comes in front of you. This is a general discussion. And as we note, all contracts are unique to the parties in particular circumstances. Therefore, any questions that arise in terms of a contract that's presented to you, and you have questions about it, you really ought to and strongly encourage you to seek competent legal advice. Having said that, and we start with the introductions, and I'll start with myself. As I mentioned, I'm Curtis White. 40 plus years of experience as a businessman, entrepreneur, and as an attorney, domestic and international sectors. I'm often on both sides of the negotiation table, sometimes as an investee, sometimes as the attorney. That puts me in a pretty unique position because I have an understanding of some of the issues that arise on both sides of the island. I am also the founder and managing partner of Energy and Transport Services, LLC. It's based in the District of Columbia. It's a CBE, and we have a very aggressive mission, and that is one of ensuring equity in the deployment of EV charging stations and equity in the ownership and deployment of EV charging points and infrastructure. And I'll ask Darren to introduce himself.
Good morning. My name is Darren Riley. I'm an attorney here in Washington, D.C., and I've been practicing law for over 20 plus years, and primarily in the area of international trade and government contracts. And what that means is I work with companies who are involved with the import-export of sensitive items. And oftentimes these clients are government contractors. So I've been supporting them with respect to their various government contract issues, whether it's at the state level or the federal level. I am a partner in eTransco with Curtis White, and happy to be here today. Thank you.
A very competent partner, I might add, in eTransco. To that, please.
Good morning. Good morning. My name is Trinette Chandler. I'm excited to be here today. I am a government contracts attorney. I primarily focus on matters in the Department of Defense, national security, aerospace, and healthcare sectors. I also sat on the other side of the table as a government contracting consultant, having worked opportunities and won those opportunities that are worth $500 million up to multiple billions of dollars single award work. My goal is to make sure that small businesses are able to benefit and thrive from the knowledge that I have, and to make sure that we get a seat at the table. Thank you.
And J.E. McNeil.
Hi, I'm J.E. McNeil. I've been practicing law for more than 40 years. I have a fairly eclectic practice. A lot of it focuses on small businesses and individuals and tax issues and business issues. But I also represent nonprofits, and I have spent some time doing some First Amendment law as well. So equity and justice is very important to me.
Thank you very much, J.E. Now, what's the purpose of this webinar that we're doing this morning? And why are we excited about it? And so, first of all, let's just tell you, give you an overview of what we plan to do and what we plan to share with you this morning. We're going to chat about the structural relationship of DCSEU and its contract manager. It's certainly something that we've learned in the research and the numerous conversations we've had with DCSEU directly and indirectly with DCSEU counsel through senior personnel over at DCSEU. There are pre-qualification requirements that you will hear about. Some of you may be familiar with it, some of you perhaps not. We have a subcontract template, and you notice it's a subcontract template. You'll get an explanation as to why it is a subcontract template and not a contract template. Green contracting opportunities beyond DCSEU. So the question is, what's the rationale for that? You will get a snapshot of some of the contemplated contract awards that may be available in fiscal year 2023. And that amount, Darren will share with you. But if you look at the bipartisan infrastructure law and you look at the Inflation Reduction Act, NEED, the climate bill, you're talking about 1.2 trillion in round numbers and 369 billion in round numbers. That's about 1.6 billion, 1.6 trillion reasons to look beyond just DCSEU and just the District of Columbia. So when we were brought on board to do specifically DCSEU, based on a number of conversations we had, we thought it would be important to plug in even a brief one, but plug in a second part of this webinar, which is part 2, and that's dealing with contracting in the green economy. In that regard, Trinette will share with you a snapshot today dealing with CBE status versus the federal DBE certification. We'll deal with that more extensively in the part 2 of the webinar. So now let's go to some issues that were flagged for us based on conversations we had with DSLVD, conversations with the CBEs assigned to us, conversations with CBEs not assigned to us as part of the grant, but other CBEs, with PTAC, and certainly with DCSEU. So these are some of the issues that arose with respect to contracting with DCSEU. One was the need for more info and accessible information on contracting opportunities. The areas and the scopes of work perhaps were not as clear as some of the CBEs perceived that perhaps they could be. There's a need to illuminate the contracting process a bit more. Companies are finding it difficult to obtain contracts even once they have pre-qualified, which obviously leads to the question of some of the CBEs raising the question, well, should I be focused on trying to contract with DCSEU or perhaps spending my time and my limited resources someplace else? Financial support for upfront costs, particularly a subject that's been probably spoken about, we know, on the accounting side, and we know as well on the marketing side. And it's something that's in front of DSLBD as well as DCSEU. But that's a front-loading cost associated with the insurance. We certainly have heard that it would be very helpful to have NIGP codes assigned to scopes of work and bridge financing. So, having said that, let me just go to some contract principles, what I'd like to refer to as Contracts 101. The subcontract template, if you haven't seen it, you'll see it today. It's 85 pages. The first 22 pages are the narrative and contractual binding provisions of the contract and the signatory page. However, the balance of those 85 pages are incorporated in that contract, and therefore they are part of the contract. So it is important that you read all 85 pages of that subcontract, not the first page where your name appears, and the second page where the money appears, and the last page where your signature is, but all of them. Secondly, you need to read it for a complete understanding. The flag areas that are unclear to you, to understand the obligations, especially those involving non-compliance or default. It's very important because those attachments associated with that contract are very demanding in terms of reporting requirements that DCSEU and its manager use to ensure that it is meeting the obligations they have under the contract with the District of Columbia. You need to assess whether the terms are doable and whether you believe you are in a position to devise a work plan to ensure satisfactory performance under that contract. The last 2 points are important. One, when you sign it, what you're saying is, I understand it and I agree. Contractor circuit closes on you at that point. And the four corners rule, I'm sure most of you are familiar with, but just in case, let's reiterate. If it's not in the contract, in general, it's not an enforceable point. There are exceptions to this, and there are exceptions to, in many parts of the law, and there are exceptions here. We're not going to deal with what the exceptions might be. I think it's sufficient for you to bear in mind that the four corners of that contract are the four corners of a document that bind you and that give you the rights and the obligations under that agreement. Let's go to the next slide, please. So Darren now is going to share with you some information that, from a personal level, certainly I learned about DCSEU based on the conversations we've had. Darren, please.
So in proceeding with these contracting opportunities, it's important to understand who you're dealing with. And there are two primary entities for purposes of these contracting opportunities. First, as Curtis has already explained, is DCSEU. So who is DCSEU and what is their mission? DCSEU basically is organized to help residents and businesses use less energy, save money. I mean, that's the goal of the organization. Since 2011, it has delivered financial incentives, technical assistance, and information to thousands of DC residents and businesses, helping them to save millions of dollars on their energy costs. So as you can see here on the slide, they administer programs in DC to reduce greenhouse gases emissions, increase energy savings and renewable energy, generating capacity, reducing growth of use of peak electricity. So it's a variety of different programs, all with the intention of helping to promote the green economy and energy efficiency in Washington, D.C. But in addition to DCSEU, you have the Vermont Energy Investment Corporation. And this entity is a nonprofit based in Vermont, established in the 80s, and its mission is to reduce the economic and environmental cost of energy use. It's grown into a company with a footprint from Hawaii to Ohio Valley, District of Columbia, Vermont, and beyond. And it essentially was formed to make clean energy options affordable and accessible for all. Now, how do these two entities work together? And what are their roles? So the Vermont Energy Investment Corporation is a contractor and is the manager of DCSEU and the entity itself. So they're responsible for managing the operations of DCSEU, administering the various programs that work to increase the renewable energy and energy generating capacity and reducing the growth of peak and the variety of programs that were mentioned under the auspices and description of DCSEU. So these two entities work together, and again, it's VEIC, or the Vermont Energy Investment Corporation, is operating and managing DCSEU. So they're doing that. That relationship is established through a prime contract that VEIC has to manage and operate DCSEU. So as a private contractor, any opportunities with DCSEU are going to be subcontracts to the prime contract that VEIC has to run DCSEU. So the RFPs, the RFQs, the various opportunities that we'll take a look at today, those are all going to be subcontract to the prime contract that VEIC has to run DCSEU. VEIC, as part of their responsibilities, they oversee all modifications to the work orders that may be issued pursuant to a subcontract, and they coordinate the reporting requirements. So as a subcontractor, if you obtain one of these opportunities, you will be working directly with VEIC in fulfilling those responsibilities and obligations. To qualify to become a direct service provider with DCSEU, a couple things need to take place. You must be registered and active CBE to qualify for the CBE SBE preference points that are awarded when reviewing your proposals or responses to proposals. You have to pre-qualify under DCSEU guidelines and program protocols. So there are steps you have to go through in order to pre-qualify to pursue these opportunities. And as a CBE, you either need to possess the skill set or register with the Train Green program and get certification through that program to obtain the skills that they're looking for in order to fulfill these opportunities. So let me tell you a little bit about the Train Green program, and it's the Train Green Sustainable Energy Infrastructure Capacity Building and Pipeline Program. And information about the program is available on the DCSEU site, and it's a training and credentialing and certification program for CBEs and for CBE eligible firms. So even if you're not quite a CBE yet, if you're eligible to be a CBE, you can still participate in the program. The program is designed to assist CBEs and CBE eligible firms in acquiring new or enhanced skills and knowledge around energy efficiency and renewable energy design, construction, inspection, and maintenance. So if you're looking for an opportunity to gain a new set of skills related to energy efficiency in that space, the Train Green program is a great opportunity. It's free to participants, and it's a program that's available on a rolling basis. So next, we're going to take a look at how do you find DCSEU opportunities? I mean, because that's what we're all here for, right? We're trying to create these opportunities and identify these opportunities so we can tap into some of those funds that are available from various government funding sources. So here at the top, you have a link to a website, and it is a link that is based on the DCSEU website, their portal. When you go to the website, you go to the upper left-hand corner, there's a menu there, drop-down menu, and you'll see opportunities for contractors. You click on that, it'll take you to a link, another link, and you'll see the opportunities to link to various RFPs, RFQs that exist right now that are available through DCSEU. So this website will take you to eventually to what you see here, this web page for contracting opportunity. And periodically throughout the year, DCSEU will publish requests for proposals, requests for qualifications, and invitations to bid. So you have to check this website on a regular basis because opportunities will be changing periodically over the course of the year. When you go to the website, go to this web page, scroll down, you'll see a variety of different current contracting opportunities that are open. We'll just take a look at one main one, which is the DCSEU qualified service providers for multiple scopes of work. In this particular contract opportunity, which closes at the end of this month, there are various scopes of work that are available for contractors. And these opportunities are open to all contractors, not just CBEs. So that's important to keep in mind. So when you pursue these opportunities, you are competing against non-CBE entities as well. But what we're trying to do is make sure you have access to the information and that you can increase your chances of obtaining these opportunities. So here you see under additional documents for this particular program, there are several attachments that are identified, and each attachment represents a different scope of work. So attachment A, for example, is for provide services to conduct solicitation of customers in the program and site assessment, energy efficiency programs and site assessments, to conduct marketing, selling of offering to end-use clients, installations of energy efficient measures, all within commercial institutions. And so it's a variety of different types of scopes of work that are identified there, from doing site assessments to marketing and selling of the program to actually doing installations. But so attachment A, scope of work, is specific to commercial infrastructures and commercial institutions. And then attachment B provides for the same type of services, except for it includes residential establishments. So those two are very similar in scope of service. Then you see attachment C, home energy kits. And basically it's for the procurement, the branding of home energy kits, and providing administrative services in support of those energy kits. Attachment D is for energy auditing and analysis, and it covers a full range of energy efficiency related auditing and design services, including technical, management expertise, and product solutions. Attachment E is QA/QC, residential inspection services, and it's for the performance of post-installation, quality assurance, and quality control inspections and code inspections to verify work performed by other DCSEU subcontractors meet the DCSEU program protocols. Attachment F deals with HVAC electrification, EEM, and it's for the identification and installation of high efficiency heating and cooling equipment, domestic hot water systems, including heat pump water heater and electric water heater for residential systems. And the last scope of services addressed under this particular contract opportunity is the affordable housing retrofit and accelerator implementation services. And it covers a full range of energy efficiency and or electrification related installation design services, including technical management expertise and product solutions to meet the requirements of DCSEU. And then, and then there's one more, Affordable Housing Retrofit Accelerator Program, which is same type of testing services and providing support for technical management expertise solutions to meet requirements of DCSEU. There are established budgets for the various contracts. So for contract attachment A is about $500,000. Attachment B is budgeted out for about $3 million. Attachment D is budgeted out for $2 to $3 million. Attachment G, $5 to $6 million. Attachment E, about 100,000. And attachment F, about 500,000. So you'll see those are just a variety of different amounts that are available for each of these opportunities, and something to keep in mind and give you an idea if you have the skills or qualifications to pursue these opportunities, then you have a better understanding of which attachment to investigate and to consider. Before we go on, I'm gonna turn it over to Trinette.
All right, very good. So my goal is to just introduce a little bit of clarity for anyone who doesn't understand the differences between the CBE at the local level in the District of Columbia, as opposed to some of the terms we might have heard in other conversations at the federal level. The Certified Business Enterprise in DC is one that basically is there to make sure that the businesses that are operating in the district are those that have been gone through a vetting process, they're certified, and there's an understanding that they are there to help drive the economy and drive jobs and job creation and business within the district. There's some requirements for that CBE though that we need to be aware of. Some of you may know, but I just want to just overview them for you. So you need to make sure that your business is physically located in the District of Columbia, excuse me, and that you meet one of the following criteria: that you're independently owned, operated, and controlled. What does that mean? That means that on the day-to-day operations, as well as those strategic operations, that they're controlled by someone who is a resident or an owner that's here in this district. It's 50% owned, operated, and controlled by a district-based enterprise or not-for-profit business. Also, it's owned, or it could be owned by a non-district-based business enterprise or a not-for-profit business, as long as more than 50% of it is owned by district residents. Again, it's about keeping dollars local and making sure that business that's conducted in this district actually stays here and benefits the residents. It's important for a CBE that this chief executive officer and anybody who's at the highest managerial level actually is one that is doing those functions in the district. You also need to meet one of the following 4 standards. Either be 50% of the employees are residents of this district, excuse me. The owners of more than 50% of the business enterprise are residents of the district. You're seeing a theme here, right? Or more than 50% of the assets of the business, excluding the bank accounts, are in the district. So if they have property, if they have, brick and mortar businesses, things like that. And then more than 50% of the business gross receipts are from the district. So that's at the district level, right? But we often get questions about how does that relate to the federal level? And does the CBE designation at the district level give preferential treatment at the Department of Transportation for the DBE, the Disadvantaged Business Enterprise designation? I'm here to tell you, friends, that it does not. They are 2 separate programs, even though some of the criteria are very similar. If you want to be a DBE at the Department of Transportation within the district, you need to apply to that program separately, right? Similar qualifications, but it's a separate program. The program's goal, as with all of the programs I'm going to discuss with you very briefly, is to promote transparency, competition, equity, and overall ability to access and have a fighting chance to secure contracts with either the district or at the federal level, which I'll talk about now. So we talked about CBEs and we talked about DBEs at the DC level. At the federal level, there are similar programs that align. We'll talk more about them on Thursday, but just suffice to say that at the federal level, instead of calling these types of opportunities CBEs or LBEs or what have you, we call them federal set-asides. You may have heard about the 8A program, right? Or the Woman-Owned Small Business Program, Service Disabled Veteran-Owned Program, Hub Zone programs, which stands for Historically Underutilized Business Zone programs, which are quite a few areas around the DC area, so on and so forth. Those programs have criteria that are basically meant to rectify discrimination and things that have happened in the past where people have not had a fair shot to go for contracts. And so you'll see that there's an alignment, as it were, between what you see at the district level and what you see at the federal level. We'll talk more about that later, but I just wanted to give you guys a heads up of what's to come on Thursday. Thank you.
Thank you for that. So at this time, we're going to actually take a look at the subcontract template. So I'm going to switch my screen here for a second. We're going to actually view the actual contract. So I'm just give me a moment here. I'll change out the sharing. All right, can you see the contract? If somebody can just give a signal.
Yes, I can see it.
Okay, great. Thank you.
Will this all be shared afterwards, the content?
I'm sorry, repeat that.
Will the slide deck and the subcontract template be shared?
Yes, yep, we can share it and we'll provide that to Kate and the team to send out to the participants.
That's a good question. Now, we're going to take questions afterwards, but that's a very good question. Let me just say that any documents, any information you see here that you have questions about and we can't answer today, we will certainly take the questions and endeavor to get back to you as quickly as we can. I can't promise it'll be before Thursday, but we'll get back to you before 3 or 4 days will pass. Thank you for that question.
All right, so let's take a look at this contract. And just so you guys know, I guess the contract. So as you see here, this is an indefinite quantity subcontract agreement, and this is just the standard template that VEIC will issue to CBEs that are awarded contracts. So as with all agreements, you have the preliminary statements up at the beginning that set forth the manager's relationship with DCSEU. So this preliminary statement just explains that VEIC has a prime contract and gives the background of the premise for the contract and it sets forth the relationship with DCSEU. As you scroll down, you have the basic terms of the agreement. And the first is the definitions, which are included in attachment at the end of the document. But then you get down here, start to get down here to the meat of what the agreement is about, and that's the scope of services. So here, a couple of things to just point out, and we're not going to walk through every single term of this contract because it's, 65 pages here. So that would take all day. And I know it's exciting to do, but we're not going to do that, unfortunately. So we're just going to highlight some key terms here for you. So one of the things we want to talk about is just the term of the contract itself, and that the term, so you'll have this contract or the subcontract that will be issued to you, but under the subcontract, once it's in place, you'll be issued work orders for specific tasks. And it may be a series of work orders that you receive from under the subcontract. But one of the things to keep in mind is that the term of the work order and the term of the subcontract are going to be different. So a work order may be, the subcontract may be for 5 years itself in term, but a work order that's when it's issued may be issued for a 6-month period. So just keep in mind that there are going to be differences there, but you need to pay attention to the terms of the work orders as it relates to the term of your subcontract with DCSEU. And also one thing to keep in mind is that even though you have a subcontract with DCSEU, there's not a guarantee that DCSEU is going to give you or issue a work order. So that's something to just want to point out and for you to keep in mind. Also, there are provisions here that relate to the hours and employees that are required or that have been indicated to be working on the contract. There are certain requirements that come into play for the terms of the jobs or work. So those employees that you identify working on your projects, you have to keep a record of those and validate their hours, and essentially making sure you document their hours in case DCSEU or VEIC needs to review and your records and to verify that the employees that you identified working on your matters are actually doing the work. Any changes or modifications to the documents, whether it's the work orders or the subcontract, and primarily what we're talking about are work orders here, need to be in writing. No verbal or oral agreements, because that leads to confusion. The contract requires it to be in writing, and you need to make sure that if you're working with your point of contact at DCSEU or VEIC, that they also document any changes to the work orders or scope of work or tasks to be performed. Because what that does, if it's not documented in writing, it leaves opportunities for confusion and for money to be lost, honestly. So, and we don't want that to happen. As I mentioned before, just want to point out the employee count and reporting requirements that exist. There are specific provisions and regulatory requirements that come into play, and I believe, Jeanette, you'll touch a little bit on that later when you discuss compliance. There's an ongoing obligation to update employee hires. So again, you have to indicate who the employees are that are going to be working on the projects and what skill set that they have and what they're going to be specifically working on. So you have to update DCSEU under the requirements of the contract to ensure that they are aware of any additional employees or new employees that are going to be working on the projects. Next, there are a couple of things about NTE and general compliance. I'm going to turn it over to Trinette to take it from here.
All right, thank you, Darren. So compliance is so critical when you're performing on these contracts because there is an entire office. Let's talk about First Source, for instance. There's an office of First Source compliance in the district. Their goal is to make sure that all of these regulations that Darren mentioned a few minutes ago are adhered to. The First Source law is one that basically gives priority to any district resident so that if there's any opportunity that's funded with municipal dollars or programs, that they have first priority. There are some thresholds that we need to make sure that if you're going to be in the First Source program, that you adhere to. First of all, 51% of all new hires need to be DC residents. 30%, 35% of apprentice hours used to be 35% need to be from DC residents. Now, that number has changed up to 60%. So 60% of all apprenticeships, those hours need to be with DC residents. 20% of all journeyman hours need to be with DC residents. 51% of all skilled labor and 70% of all common labor need to be from first source DC residents. Why does this matter? Because we want to make sure that in the district that we are giving district residents the opportunity to skill up their labor, to have meaningful jobs with a meaningful wage that could sustain families, and to do so on these construction contracts and all of this government money that's here. It should be those that live in the city first that have the right of first refusal, right? So that's number one. First source is for any contract that has been granted to a company in the district for $300,000 up to $5 million. There has been a lot of conversation around the first source contract, but it really does have a meaningful and beneficial impact on the city. Non-compliance is an issue that a lot of these companies are getting tagged with. You want to make sure that you're not one of them. So you want to make sure that when you're hiring folks that you're actively vetting where do they live and all of that, and that you're maintaining that obligatory balance that Darren mentioned a few minutes ago. Why? Because the Office of Compliance for First Source, they will come in and they will perform audits. They will continuously look at your books. You are required on the 15th of every month to provide a report to their office that says what your numbers are, what the thresholds are, and how you're meeting them. And if there's an issue where you're not able to meet them, you need to proactively give the Office a mitigation plan on how you plan on meeting those requirements so that you maintain the numbers, right? And then also quarterly, you are required to provide a report to that office, which then turns it over to Mayor Muriel Bowser, that says that the numbers are being met. Why does this matter? Well, at the state level, at the local level in DC, these numbers are critical because there's been sort of this feeling that everybody comes into DC, they work in DC, and they leave and take their dollars elsewhere. So this is basically the line in the sand against that. This is no different for those who are going to move into the federal sector. This is no different than at the federal level when you have those set-aside programs that you're making sure that the right folks that are supposed to be in those programs are certified and are serving in those programs. So this is just another way to make sure that folks that haven't had an opportunity to bid on work or to get work with whatever agency it is, that they have their fair shot. Thank you. Darren?
So continuing on, next we're going to go down the contract and go to performance period. So the performance period, again, key term, you just want to pay attention to. It establishes what the performance of the period is for the contract. And for this particular contract here, it's going to be between whenever this contract is signed up until September 30th, 2026. Okay, so this contract that BEIC has with DCSEU is only good up until 2026. So that means the subcontract is only going to be good up until 2026. So that's why you see here that it says it's between the effective date, so whatever date your subcontract is signed with the EIC, it'll run through September 30th, 2026. Now, it may be renewed down the road or a new prime contract issued to BIC and more opportunities created, but you have to, that'll be determined at a later date. But the dates of performance here are laid out for each year, and that's important information just to be aware of for your planning purposes. As we just continue to go through down the contract, we get to the next main section here will be fees and payments. And again, you want to understand the payment process for this contract and to understand and want to ensure that you're going to get your money when you're supposed to get your money. Oftentimes we overlook these terms and fail to realize that we are able to, and I say we as subcontractors or contractors are able to enforce these provisions just like our prime can or our customer can against us. When they are obligated to pay us, they need to adhere to the terms of these contracts and pay us. So it's important to understand when the payment process, what you need to do to get payment, how you need to submit your invoices, make sure that they are complete and accurate, because you don't want to give any reason for them to deny an invoice or to turn away or to question the invoice. So make sure you meet all the requirements that are established in attachment D to this subcontract that lays out all the requirements for submitting invoices. The next provision under here is fiscal year NTEs. And for NTEs, I'm going to turn that over to Trinette to address.
Yes, thank you. So NTE stands for not to exceed. That's the ceiling for the level of work that you may be providing to the government. So if you're in construction, that level is like $23 million. That means that you are a firm that cannot have, on average, over the previous 5 years, more than $23 million in business, et cetera. So that's one level. And then also on your contracts, when you're working, you do not want to exceed that not to exceed level, because you will not be paid more than likely. If the government says the contract's worth $1 million, do not perform $1,200,000 worth of work, because that $200,000 that is not part of the original scope of work puts you at risk and you probably won't be paid. So you just want to make sure you're keeping track of those, what we call resource burn. In the industry, you have someone who always has their eyes on the number and making sure that you're performing not only within scope, but that dollar figure is hit. Okay. Submission of invoices, Darren's already covered, so I'll turn it back over to you. Thank you.
And actually, this is a good opportunity to hear from JE, who will talk about some tax matters to keep in mind as you're going through this process.
Well, no business can operate without being involved in taxes, and so we wanted to talk briefly about some tax issues. It's actually pretty straightforward. So as part of your process of becoming a CBE, you had to show that you had clean hands, and part of that was to show you were up to date on all your taxes. We want to remind you that the obligation to be up to date on your taxes didn't end when you got that designation. You need to continue to stay up to date on your taxes. I'd like to refer now to Section 23 of the contract. It's the audit adjustment. This is the situation where after the contract's over and you've been paid, there is an audit of the work you've done. And in the audit, it is determined that you were paid something you should not have been paid. Perhaps you were paid over your $1 million limit. Perhaps you did work that you weren't asked to do. It can be any number of things. But under this provision, DCSEU can claw back the money. So what happens with that? Well, if you've ever looked at a Schedule C or 1120 form in the section about income, you'll see that there's a line that says returns and allowances. And that's where you would put the amount of money that you paid back. And it would reduce your tax burden. But a clawback may have happened in a different tax year than the tax year you were paid the money. So where does that money fall? And that is dependent on whether or not you have an accrual or cash basis of accounting. And you need to talk to your tax advisor about that to determine which year you deduct that clawback amount. Now, even beyond clawbacks, I mean, what happens if you spent money on something to complete your work, but it was disallowed by DCSEU? The good news is, although it may not be reimbursed by DCSEU, it doesn't keep it from being a business expense. The only problem would be is if you have a tax reason for it not to be a business expense, such as you paid a government fine. You can't deduct fines. A mini client has been unhappy to find out they can deduct their speeding tickets. And you can't deduct a bribe, which I think we would all agree is probably a good thing. So, but other than things like that, you can still deduct it as a business expense, even though it's not reimbursed. Now, in my 40+ years of legal practice, one of the things that has become perfectly clear to me is that one of the biggest reasons businesses go under is because they don't stay squeaky clean in their payroll tax area. Sometimes employers are tempted when they're cash strapped to use the money that they should be paying payroll taxes with to pay some of their other bills. This is actually a crime because you're using your employees' money that you've withheld from their pay to pay your own bills. While the crime is generally not prosecuted, the IRS will file penalties and interest on the unpaid taxes, and many businesses have found how fast that they multiply and have led to bankruptcy of the business. But, and this is important to remember, the owner of the business is still personally liable for those taxes and penalties and interest. So it's a very bad business decision to do this. Now, some employers try to convince their employees that it's in the employee's best interest to be a contractor and to be supplied with a 1099 NDC. Aside from the fact that the employee loses many legal benefits such as sick leave and worker comp protection, the employer risks the IRS concluding that the personnel are in fact employees. If this happens, the employer will then have to pay the employee taxes that should have been paid in the first place, plus penalties and interests. And this is true whether the employee paid the taxes on their return or not. In addition, employers are often tempted not to issue the 1099 NEC forms. If this happens in an audit and the IRS sees it, then the expense for the labor that NEC would have covered is not deductible, and thereby the business tax liability is increased. Now, I want to encourage you that when you get a letter from the IRS or DC government over tax issues, don't ignore them. Start by opening the envelope. Now, people laugh when I say that, but I can't tell you how many hundreds of envelopes that have been brought to me unopened for me to open for my clients. People just freak out and they don't even open the envelope. Second, after you get the envelope open and you read it and you consult it with your tax advisor, respond. Even if your response is, I don't know what this is, it's better to have responded. It puts you in a better position to vis-a-vis resolving the issue. Often the response is, for many of my clients, it's, no, IRS, you're wrong, and here's why, and here's the proof. And the problem is solved, but you can't solve the problem without responding, right? Sometimes the response is, yes, I do owe that money. And then you still want to respond, and you want to send any amount of money you can with that response. Even if it's a few $100s, by sending that money, you start reducing penalties and interest, and you put yourself in a better position to negotiate a payment plan and penalty waivers, which sometimes you can get. Finally, I wanted to mention that there are tax incentives for the green economy that may be available to both residential and business consumers of green energy. If you're in the business of installing solar panels and energy cells, you may want to let your clients know about IRS Form 5695, which provides tax credits for residential property. The Inflation Reduction Act extended this credit to 2034 and included battery storage technology. There was, at the time, a lifetime cap, but that has been replaced with an annual cap. So it means that if you've already spent your lifetime cap, you can deduct every year something as you continue to make your house or your business more green. And IRS Form 3800 provides the same kind of benefits for businesses. Finally, I'd like to note that there are rebates available under the Inflation Reduction Act as well. But we'll get into those in more detail in the next program, I suspect. In addition, you might want to let your solar panel clients know about SREC, or SREC offsets. An SREC is a financial instrument issued at the state or district level, which allows your client to earn money for the electricity generated by their solar panels. Your client can earn one SREC for every milliwatt hour of electricity they generate. Companies which need carbon offsets buy them. And there are actually companies which have the sole purpose of trading SRECs for individuals. I've been told that Washington, D.C. has some of the best annual earning rates for SRECs in the country. Passing this information on to your clients may encourage them to create a bigger green project. They'll feel like they have more money available to them to do that. But be sure to tell them to check with their tax advisor. You should make it clear that you're not giving them tax or financial advice.
That's good advice.
All right. So now the next provision that we have that we want to point out deals with independent contractors. And as you see here, it's section 6. Curtis, did you want to address this section?
Enough. Independent contractors. First of all, I've sat here and this team and I have spoken probably every day for the last 45 days. And I've gotten an education this morning. I thought I knew everything, but I've gotten an education this morning. So before I proceed, let me just thank them for educating me a bit more this morning. Independent contractor. We're moving down into the general contract clauses now. Let me not suggest that's the case for this insurance item, which is the next that will pop up. But the independent contractor, Jay just finished chatting about some of the inclinations that sometimes of employers moving employees over into an independent contractor status on the theory that it saves them money, provides other benefits for them. In this instance, Darren has given you the breakout of the management relationship between Vermont Energy Investment Corporation and DCSEU. The simple fact here is you're dealing with two parties. One is DEIC and the other one is a business sometimes one could refer to at least as a DBA, doing business as. And neither one of those wants a third party claim filed against them. So your subcontract has an independent clause in it. That's probably clearly a non-negotiable clause in this contract. And the purpose for it is to ensure that a homeowner, business owner, multiple dwelling unit owner, whomever, is dissatisfied with the work that's been performed by your company, has the right to then go against DCSEU or VEIC. So that is one of the fundamental reasons it appears in there. And just to reiterate what Jay just said, if you have independent contractors working under you, obviously bear in mind your responsibility to provide a 1099 to that independent contractor as well. Moving to the insurance requirements. The insurance requirements under the subcontract template, we've heard quite a bit about it. I know the company that's doing the accounting for the CBEs has had a number of conversations with the CBEs, and the same thing applies on the marketing side. They're onerous. There's no way to get around it. That it's not just liability insurance that you're looking at, but because you're working with the public, there are numerous other insurance provisions that you're faced with, and they're expensive. And they may be expensive, bumped up a bit more on the expense for a couple of other reasons. we're not going to get into the weeds on waiver of subrogation, but that is a provision that may affect the carrier rates that are quoted to you. A new business will affect the rates. Depending on certain industries and certain kinds of construction you experience will affect the rates. We've heard stories of from DCSEU as well as from the CBEs that the rates, once they looked at the rates, they decided, oh no, that's it, I can't proceed. Or see some CBEs who were successful were not able to get insurance. On the flip side of the coin, we also understand that there are a couple of CBEs with, or perhaps more, with all kinds of insurance, but they have not received a work order or subcontract yet. But the insurance requirements are onerous. There's been some discussion about trying to figure out a way to relieve some of the financial pressure on the part of the CBEs in terms of meeting the insurance requirements. Let me just say that for purposes of qualification and qualifying under the DCSEU guidelines and the protocol, as Darren explained, you're not required to have the insurance for that. On the other hand, you are required to have the insurance before you commence work. And sometimes there's a slip between the cup and the lip, if I could use the phrase. So you may have signed, you may have a purchase order that's out there, but the work hasn't started, which means you can't bill against it. So you're front loading that cost and you're carrying it for whatever period of time it's out there. So be aware of that. There's a notice of cancellation or modification in the stop work that's under the insurance. What does that mean? It means simply that if it appears that you don't have the required insurance that is you're required to have under that contract, there's a notice of stop work that is available to DCSEU/BEIC, and you can probably almost guarantee that notice will be exercised. Why? Because it then does potentially expose those entities to some kind of a problem if they knowingly sat with a CBE who did not have the requisite insurance and did not do anything about it. So you can assume that if you don't have it, that right of notice will likely be exercised under there. And now we're going to something that is a very pleasant sight that popped up in the midst of it. Anyway, let's go to the next slide, please. Well, I can go off the contract, no problem. The representation and warranties. Do I have that, Darren? Do you have that? I have it. Representation and warranties. Well, first I will say that you're looking at that contract now, look at it later after we finish this. You notice that the whole run is the representation and warranties of the subcontractor. I don't think you see anything in there on the warranties on the other side. If you do, the length of those are not at the same level of the length and the breadth of the ones that apply to the warranties of the subcontractor. You've gotten from Trinette, from Darren, and JE, in different substantive respects, the due diligence requirement associated with performance under this contract. The requirements extend to the protection of adjacent property if you're working on a homeowner's property. Trinette has given you the information regarding first source, and she indicated we'll discuss that a bit more in the part 2 of the webinar, but be aware of that. Let me also mention that these are bases for potentially placing the CBE in a position with breach of contract. And so you can't take these lightly. you can't assume that, all right, I'm gonna make this promise and this warranty, and that's okay, because material misrepresentation creates problems for you under the contract, and it's quite frankly a basis for material misrepresentation for contract being terminated. Darren has mentioned the inspections, so I'll forego that. We'll step to the settlement of disputes. This contract makes clear that VEIC and DCSEU are interested in trying to resolve this on a gradual level of progression. So first, they want the parties to sit down among the parties, or if you want to call the third party in, and try to negotiate a resolution to whatever the dispute is. Then you sort of step up to something that's more formal. You move into a mediation process. If that doesn't work, then you go to binding arbitration. And those binding arbitration and the results of that, and the determination, the decision of that, will govern. It forecloses the right to, if you're in the middle of a dispute, to walk down to Superior Court, or if it's something that gives you jurisdiction, go to the Federal District Court and file a suit, except the subcontract template expressly allows for the parties to seek injunctive relief. So to put it differently, it allows the party to walk into the courthouse and either ask the court to require the party to do something, or require the party to stop doing something. Now that's the injunctive relief. That is available to both parties. Outside of that, to the extent a dispute arises under this contract, it's going to be handled out of the court system, either through private negotiations, mediation, or arbitration. Indemnification is exactly what I would hope that many of you have seen in other contract works that you've done. And that's basically if you are responsible for injuring someone, there's an indemnification clause in there. On the other hand, if somebody figures out a way to get around you as the contractor and to seek redress with VEIC or DCSEU, that indemnification sort of circles around as well to indemnify on that side. We mentioned termination for cause and some material breach of provisions in the contract that are considered material. I'm not going to try to explain what materiality is, but under those representations and warranties, breach of some of those, you're going to generally assume that they would fall within that category of materiality. Now, you should be aware of the fact that this subcontract can also be terminated without cause on a 30-day advance notice. We will not speculate in terms of why that provision is in there, except to offer, this is my personal view, that it's probably related to the contractual relationship between VEIC and DOEE. DOEE is the contracting party with VEIC that gives it the authority to manage DCSEU. And the VEIC's contract has to be approved every year by the District of Columbia government, the DC Council. It probably wants to ensure that it does not have any lingering obligations in the unlikely event something arose and a contract is not renewed or summarily terminated for some reason. But without further speculation on that, be aware of the fact that there is a 30 days advance notice, and there is a clause in this contract where it can be terminated without the cause. I should also mention that if we could drop down to the non-compete clause, section 21, if you've qualified and you are a subcontracting party, you have an obligation to ensure that you're not engaging in activities that may be construed as competing with DCSEU or BEIC. If you are, that is also a problem. It may well be a problem that could result in potential termination of your subcontract agreement. JE has dealt very deftly, I might say, with the clawback provision on section 23. And I will say again, now we're in the general clause section of this contract, headed down towards page 22, which is narrative part. The governing law is the District of Columbia, of course. The attorney's fees spelled out in the contract. You know, ordinarily, you don't see attorney's fees sitting in the contract. You see it someplace else. But again, my speculation is that the attorney fees clause in this contract is probably related to the tiered kind of relationship you have here, DOEE contracting with BEIC and BEIC contracting with DCSEU as a manager. And so thus you have the attorney's fees. It operates generally as attorney's fees operate. Let me just say that you can put all the language and gobbledygook and legalese in there you want to put in there. If you end up in litigation or arbitration, those attorney's fees would be decided by judicial authority or the arbitration authority. They would determine generally what they deem to be appropriate, fair and appropriate under there. We're on page 9, and so I guess we conclude with the subcontract template, and I was inadvertently, of course, but I did not mention at the outset that we certainly encourage questions. I've noticed that a number of questions have come in during the presentation, and I hope we've recorded them. Questions that were directed to one of the panelists individually, we'll take it. Questions that are directed to the panel generally, we'll caucus among ourselves and see who's going to respond to it. So let me stop there. And Kate, see if you would like to make comments before we go into the Q&A session.
Thank you so much to the entire team for this. I know we have a number of folks who are on the line. We actually only had one question that came to me, so I don't know if any questions came through to your team. You might want to check and see if there were any direct messages. The person who asked the question that I received is no longer on the line. I will mention what that is, but let me encourage while we go through that question, if you do have a question and it's something you can easily add into the chat, please do that now. And then we'll also look, otherwise, please raise your hand and so that we can call on you. The question that did come in, Curtis, was whether or not there were any opportunities for information technology services companies to be involved with any of the subcontracts as far as you have seen.
I'm smiling. Actually, we're all smiling because one of our CBEs happens to be in IT technology. We raised that question with DCSEU, and DCSEU's view is that about 75% of the work is what they refer to as tradesman work or tradesperson work in today's world. The bit more conscious of my pronouns here. So plumbing, electrical work, and the like. DCSEU, and I'm not speaking for them, but their view is they don't see, for the moment, IT activity, at least for the budget that they've submitted for the upcoming fiscal year. Now, that does not mean that the opportunities do not exist. I can imagine just from our wheelhouse that there are some opportunities over on the EV side, EV charging side. There's no question about it in terms of data interface and the like. So what we've done is we've encouraged the CBE side to us, who's in IT, to take a hard look at their portfolio and to dig into the green economy and see if they could frame what requirements associated with the green economy and present that, or give that to us. And we'd be more than happy to present that to DCSEU. Our understanding is that DCSEU is open and amenable to receiving ideas. In fact, we transmitted an idea that one of our CBEs raised on a project that seemed to generate some interest on the part of DCSEU as well as PTAC, for that matter. So I think the short response is DCSEU has been asked that question. They don't see it for the upcoming fiscal year. It doesn't mean it wouldn't appear. So if there are IT companies on the line today who are part of this webinar, I would encourage them to take a hard look to provide whatever perceptions they have. And we certainly would be more than amenable to putting it in front of DCSEU and taking it up with them to see if there are project possibilities in that regard.
One of the other questions that is in the chat group is that someone asked if we can restate the budget amounts for the attachments under the opportunity that we discussed early on in the presentation. So I'll just go ahead and restate those budgets for you. So for attachment A, it was about $500,000. Attachment B was about $3 million. And again, this is for fiscal year 2022. There wasn't a budget for attachment C. Attachment D was 2 to 3 million. Attachment E, about 100,000. Attachment F, 500,000. And then attachment G, about 5 to 6 million.
Thank you for that. And I put that in the chat as well for anyone who is looking for that. There is also another industry question that's come in.
I apologize.
So,
There's also attachment H.
Yeah, I do not have a budget for attachment H.
But we'll see if we can get it for you.
Thank you.
thank you for that. The other question that has come in, it's a similar question. It is a different industry. The individual works for an engineering facility inspection CBE. Based off of the review, attachments D, E, and H appear to be focused on inspection or professional services. Is that also your understanding?
Attachments D, E,
H.
yes. Yep, I think all of those have scope of works that include different types of inspection.
That was going to get there is an attachment that we can pull up. We don't have it here, but we'll make it available. But Darren is right. Engineering, there is a Train Green program where they will take engineers who have some advanced skill levels, and they will take them through the Train Green program and use them as part of a management process. We don't have it, but we will post that. Kate will get that to you, so you will have it. But the short answer to it is the answer that Darren just gave, and that is, it is available. It's a work item.
Thank you for that. And I definitely want to encourage folks, if you have questions, to raise your hand or drop them in the chat. There's another question that came in. Is there an overall page count limit for the RFQ?
Is that what, Kate? Could you repeat that?
Is there an overall page count limit for the RFQ?
We can check and get back to you on that one. We can respond back and get that to you.
I have another question, and I don't know if this has come through in any of your conversations with DCSEU. I know a lot of what we focused on today, and it was great, was looking at what is available under the attachments. Have you had any conversations regarding the contracting opportunities that come out related to Train Green to be the provider of trainers, or any other contracting opportunities that don't come through in the attachments?
We have not. We have not.
Okay.
We perhaps should take it up with Rick. Let me say that Rick Florio over at DCSEU has been responsive. We have had a conversation with Rick very recently on a concept and the proposals, as I mentioned, submitted by one of our CBEs that they seem to express an interest in. But we've not asked specifically about the graduates or those who've been certified in the Train Green program. And so we can't give you an answer in terms of what their success rate is in terms of either employment or, for that matter, bidding on contracts as a subcontractor. While we're on that subject, let me just mention something. Darren, I believe, indicated that when these announcements are made, RFPs, RFQs, however they are, but when they're made, they're not made, they're made for the universe. So the CBEs, the budgetary projection and their target for CBE contracting is approximately 35% of the work that is done under DCSEU. And that 35%, we understand they've been able to meet over the last few years, if not exceeded. But that's 35%. Now, if the other CBEs on the line, those who are on the line who are not CBEs, but plan to become CBEs, if they're like some of the CBEs assigned to us, they're busy, but they're small in terms of staffing. 4 people, 5 people, 7 people. There are a couple that are perhaps larger, but they're busy working. And when these announcements come out, it may say that it's open for X period of time, but if it's a work item on a residence and it says that this residence or this multiple family dwelling is interested in solar, and can you meet at X time at X day? A CBE with a small staff that's not monitoring the notice requirement may not see that for a day or two. And we understand that you may have 4 or 5 companies show up. Some may be CBEs, some may not. But they may have 4 or 5 companies show up. And if the 4 or 5 companies show up and they're qualified, within a short period of time, that window may have closed on that opportunity. So we've suggested the DCSEU that it might come up with, I think what JE called a ping device or something, but JE Internet was suggesting that we come up, DCSEU come up with something recognizing that the CBEs, many are small, They don't have somebody monitoring emails all day long because they're out in the field working. So the end result, we need to figure out a way to give them as much advance notice or put them on an equal footing with someone who has the ability and the staff to monitor emails all day long. So I just wanted to mention that as well.
Thank you for that. And I feel like it's related to the next question that has come in, and it's a little bit about the schedules that are on the current attachments. And so the question is that the schedule is tight. Do you know if DCSEU will make extensions for 60 days for pieces that are here now on the attachments?
Don't want to hazard a guess on that, but I tell you what, we'll raise it with DCSEU and find out the possibilities of extension of that RFP. They would entertain one. Let me just say that if the question, the party who raised the question, CBE who raised the question, is interested, I would encourage them to contact us. Can you give them our contact info, and we can identify them to DCSEU if they are not known by DCSEU. But we will ask that question, and we'll get back to you, Kate, and perhaps you can distribute the answer. Since we have 4 or 5 items we need to follow up on as well.
Thank you for that. And I dropped into the chat for everyone, and I will say here, if you are trying to reach out to us at DSLBD, our email address is inno.ed@dc.gov. Again, that is inno.ed@dc.gov. And to follow up on that a little bit, Curtis and team, my understanding, and I'm happy to be corrected or we can get this correction from DCSEU, is that many of the attachments they expect to have for many years. And so whereas, contracts or subcontracts may operate on the fiscal year, it is anticipated that many of these will retain year over year, at least for the next several years. I don't know if you have that understanding as well.
Could you repeat that question for me, please?
So my understanding from DCSEU earlier this year is that although IDIQs or subcontracts do operate on the fiscal year schedule, that they expect many of the attachments to retain year over year for many years to come?
The answer is yes, and number one. And number two, our understanding is once the CBE has signed the subcontract agreement, there's no further need to re-qualify as long as it maintains their status. And they're in the proper status. There's no need to re-qualify. So to use an example that's been given, if I got a purchase order or work order for 6 months and they performed all that, they didn't get another one for the next 6 months or 8 months or so. There's nothing they are required to do during that period of time, as long as they are still in favorable status. And a new order comes out, then they just simply agree to it and begin to perform the work. So during that period of time, that 4.5-year period of time of until 2026, there's no requalification process required unless an issue arises regarding the status of the CBE. So I would expect that if the CBE status expired, then obviously, since that is a condition preceding, I mean, that's a primary, they can't get a contract without that. So if that expired, then they'd have to recertify and requalify.
Thank you for that.
And to further expound on your question, the point that you made, just as an example, in fiscal year 21, many of these same scopes of services were identified in pretty much the same attachments. And one of the differences from 21 to 22 is that there were some additional attachments created or additional scopes of work. So, so these are as you and Curtis have explained, these are scopes of services and opportunities that will continue from year to year.
Thank you for that. Someone did ask for a contact to engage. And so please, for that contact, send me an email at inno.ed@dc.gov so I can make an introduction to energy and services or energy and transport services. They did drop their information for the business that wants to connect in the chat. If you have additional questions, please be dropping them in or raise your hand if you would like to come off of mute. Otherwise, I do have a few additional questions for the team that I'd like to walk through. And I think it's teasing out some of the things that I think are sort of embedded in the big picture ideas of what you've been talking about today. But the question that I'd like to start with is, for many CBEs, we know that they are working very hard to get contracts, to get work in the door. And so, if an opportunity doesn't look like it's one that they can immediately close, they may move on to the next because they are very busy trying to find that. Curious, as you look not only at these opportunities, but as you look at this broader landscape that you're going to talk about on Thursday about the green economy, what are the lessons that you would suggest people take home when they think about positioning themselves for green infrastructure and the green economy?
Oh, okay, that you're asking for a treatise now. I think, first of all, as you well know, Kate, the original premise of this webinar was DCSEU. And based on the conversations we had, he said, there's more than DCSEU. It's not the only game in town. And the district is not the only game in town. It's a game that we certainly want our CBEs to play in and be very aggressive in. But the opportunities, in my personal view, given the bipartisan infrastructure law and given the climate bill, are just enormous. We will chat more about the 40 Justice decree on Thursday. But there is the position and the target of trying to ensure that 40% of the dollars associated with those two laws reaped or the benefits are experienced by underserved or historically marginalized communities and by companies owned by DBEs and Native Americans. That number is enormous. I'm told by a number of secretaries of state with whom we've spoken that if you just deal with the area that we're focused on primarily, that's less than 3% right now in terms of what's occurring. So if you're going to move from 3% to 40% on these dollars, that's a huge jump. Even if you got the 5 or 10%, you're still talking an extraordinary amount of money. So I would say, first of all, I would encourage all CBEs to look at their qualifications and spread them as widely as they can in networking as quickly as they can. If sitting in the district, you're in a pretty good position because the district has arranged in the DMV for a pretty seamless process in terms of qualification. So for example, if you qualify for MWA, Metropolitan Washington Transport Airports Authority, you also qualify for WMATA. And they have a waive-in process for a CBE out of the District of Columbia. So that's number one. So I think first to take a look and ensure that you registered as widely and as you can and as quickly as you can. And secondly, I think I would strongly encourage CBEs to talk among themselves about teaming arrangements, because in many instances, you may not have the skills to perform the work, but you may know others who have certain skills who can participate in the performance of that work. And you can walk in under a teaming agreement. DCSEU accepts teaming agreements, as all of the other agencies, whether they're federal or they're state. They will accept teaming agreements. With regard to DCSEU, if it's a teaming agreement that that has a CBE involved and a non-CBE involved, if that is the case, it is the CBE that is required to be the signatory and the subcontractor under that contract. But the non-CBE can still be a party to it. And by the way, that non-CBE can be a larger company. And so let me just put this out right now. We're not talking about fronting for some large company, which vitiates the whole concept of this in the first place. So we're not talking about fronting, but we're saying that if I have certain skills, but let me use energy and transport. We don't manufacture charging stations, but we have arrangements and accords with companies that manufacture. So if we have a contract, we are the contracted party, but we have a teaming agreement with one of the much larger operators who has the manufacturing capability to bring them to the table. That's an appropriate kind of process, but we will be focused on doing the work, and we will be focused on bringing in local residents, train them to do the installation and the maintenance of the systems. So that's a good example right there. So secondly, I would say that teaming is very important, and as part of that team and networking. And I would use the question that was raised on the IT side as a prime example. Let me just say that we have a CBE that is handling this webinar this morning. All right, that's sort of a loose teaming agreement that that's in place, and because perhaps outside of Darren and Trinette, and J.E. and Curtis White, tell you, would not have this Canyon Hotel. Put it that way. But so anyway, I would say that secondly, teaming is very important. So to summarize, one, yes, I would strongly encourage all CBEs to register as aggressively as they can, both for the district and DMV, but also to consider the federal registration process, as Jeanette explained, and we'll chat about more. And secondly, to look closely at teaming arrangements among themselves, because you can walk into DCSEU and any other potential contract under a teaming agreement.
Yeah, one more thing. So also at the federal level, since Curtis mentioned it, you can go, even now, we still have 10 days left in the government contracts year. You can look at the forecast, you can look at, at their forecast for next year, but you can go out to sam.gov, sam.gov, and look for opportunities that are in your NAICS codes, which are similar to what you would call the NIGP codes here. And you can just go in, if you're an electrician, just type in electrician, see what comes up, and then put the date range from today until, let's say, the middle of October. There's opportunities out there right now that small businesses can pursue. You want to make sure that you're registered in SAM and all of that .gov. It's not a difficult lift, but there's still some fight left in this year, is what I will say. We keep going to the very end, and so if you're a small business out there right now, is your time to search early, but search often, because the deals are happening. The government might, what we call, let an RFP on today, it may be due on Thursday, and they may award it on Friday. That's how quick some of these are going. So there's still some good eating out there, as it were. Thank you.
Thank you for that. I want to make sure there are no additional questions from folks who are on the line. So please interrupt me if you do have one. Another one, I have a sort of a even bigger step back sort of perspective question while we have you on the line. I think as we looked through this contract review and you talked a lot, and thank you for that. And you talked a lot about the need to read an entire contract in a general perspective when talking to CBEs about reviewing contracts and could you speak to any principles or perspectives on negotiating terms of a contract or times in which someone may need to get legal advisement to decide whether or not to walk away from a contract if it's not the right opportunity?
The DCSEU views that a lot of the provisions in the contract are not negotiable. And I can't tell you what those provisions are because it's pure if I were to suggest it would be pure speculation on my part. I mentioned one, insurance. And I believe that the real reason, one of the reasons for that is because of this tiered relationship that BEIC is sitting between DOE and DCSEU, and I guess the city council and the contracts as well. So some of the provisions are non-negotiable, but I'm not going to speculate in terms of which ones are and which ones are not. I will say this, we have raised a couple of questions with DCSEU regarding the contract, and they've taken it back to DCSEU legal, and we are looking at the possibility of trying to come up with some language. I don't believe we're going to have an opportunity to do it before the end of this fiscal year, but we're committed to trying to come up with some language to modify a couple of provisions in the contract that create what we consider to be unnecessary risks on the part of the CBE. So I do know that they've been amenable to a couple of suggestions that we've made regarding the contract and perhaps modifying some of the language. So if there are questions that a CBE has during the time that they've qualified for a contract and they have one in front of them, I would encourage them to at least raise the question. Because the old adage goes, you don't ask, you don't get. A lot of times when you ask, you don't get either, but you certainly will be in the same place if you don't ask. So that's my response to that. Darren?
Yeah, a couple points I'd like to share. So in the context of the DCSEU subcontract, so that is as Curtis pointed out, that is a set standard template contract form that they're going to utilize to establish the relationship. Now, in this particular situation, the opportunity to negotiate or to have that exchange of back and forth really is going to be at the work order level, because that's really where, you're performing the work and you're setting what the terms of what you're going to be getting paid and understanding what is the specific task or scope of work you're going to be responsible for. So that's really going to happen at, each of those work orders that are issued up under this subcontract. But on the general from a general standpoint, when you're working with, if you're in a situation where you're subcontracting with a prime, and we're not talking about necessarily in this situation where you got this standard subcontract template, but the main thing I would always advise clients on is making sure that the subcontract accurately reflects your understanding of the arrangement, of the deal, of the terms. Because oftentimes, clients will enter into contracts with a prime partner. And when they bring it to me and we discuss it, the first question I ask them, okay, so what is your understanding of how this relationship looks and what should be taking place? And then I compare that to what I'm reading in the subcontract, and it doesn't reflect that. So it's important to just make sure that when you enter into a subcontract with anybody, with any entity, that it reflects it accurately reflects your understanding of that relationship and the terms of that relationship.
Thank you so much for that. I think if we have no more questions, what I might do is to see if we have closing remarks and closing thoughts from each of you for today. There were so many good takeaways today, but if you could share just one takeaway you hope that the folks take away from this talk today from each of you, that would be fantastic.
I'm going to defer, and then I'll add the tag.
Okay. I would say just be ready. Be ready, be ready. There's a lot of opportunity out there in both the DC government space as well as at the federal sector, because I know there are questions there. Always have an intentionality with the way that you seek out opportunities and you track them, even if you're tracking them in a very simple Excel spreadsheet. Be intentional and say, hey, every day for half an hour, I'm going to look on dc.gov or I'm going to go to sam.gov, whatever it is, right? That's really the only way to kind of get over the hump of seeing what's out there and getting a feel for what the industry will bear. And then you can set up alerts on your phone so that you can, or on your system so that you can get them automatically. But I would say be ready right now. There is money out there and the government is willing to award it. You just got to find it. And so that's why we're here. So thank you for your time.
Yeah, and I would say, really, I think it's important to take a look at your skill set and specifically identify what capability in your skill set matches opportunities for the green economy. And if you don't have a specific capability at this current time, then take advantage of programs like the Train Green program so you can develop the skill set to meet the needs of green economy. Because to me, that's the crux of it, right? Like, what is your skill set and how can you match it to what the needs are for the green economy and where the opportunities are? So that's the first step in my mind, is identifying and developing that skill set so you have something to come to the table with that people want, that'll be useful and beneficial for the green economy. Okay.
It's hard to top those remarks, but I think my takeaway actually from this is how proud I am to be a citizen of the District of Columbia and its efforts to have an equitable and just society in every level of the process.
You can tell Jay's commitment to human rights, can't you? But she's a hell of a tax lawyer too. I just throw that out there. I have two comments. The first is to everybody on the line, don't think that the touted 40 Justice Act is something written in stone. The reality is the big boys are not necessarily interested in your plan in their sandbox. And they will have a conversation with you. They will smile at you, but they're chasing that $1.6 trillion. And they don't necessarily want to slow down. I'm being all inclusive. It's not fair. There are some companies out there that are committed to the effort. So it's not fair for me to frame it that way. But I'm making that statement for this purpose. Don't be discouraged because you're fighting to get your foot in the door and you're finding it difficult. Because sometimes it's difficult just because of all of the paperwork that's associated with it. Sometimes it's difficult because there are others you can't quite see who want to make it difficult for you. So one of my comments is you cannot be discouraged. I do believe, and certainly the district has shown, I think DSLBD has shown by doing this back office service. I have to say this. I've raised this now in 5 or 6 states, and 5 or 6 states that we are talking to, they were amazed that the district had put together this kind of program to try to encourage small businesses to get in front of the line and chase some of these products. So, one, I would say, don't be discouraged in the process, and 2, I agree with Annette, Darren, and JE. That is, if you don't have the skill sets now, look at where you are, get in one of the training programs, get some of your employees in the training programs, and begin to aggressively pursue the contracts. And if you can't do it all by yourself, consider a teaming arrangement with other CBEs in the district. And on that, what I would say is, well, I'm amazed. We're almost on schedule. As I look down at the watch here, what we tried to do this morning, and I hope we've done something, is in this respect, and that is try to encourage you to look hard at DCSEU as contracting possibilities. Understand that just because you clear the door and now you're eligible to contract, I think as Jay said, it's sort of like graduating from high school. Because you graduate doesn't mean that you're in college. Or you're running the race. Just because you're in the starting blocks doesn't mean that you're starting to run. When you sign that subcontract agreement, all you've done is qualified to compete. That's what you've done, which means that you have to have the mechanism to try to respond aggressively when RFQs and RFPs pop up. So our overarching objective here this morning was to give you an idea of what the contracted requirements are, because clearly from the CBEs assigned us, there was not a full understanding of what DCSEU was. We hope we've improved upon that this morning. And we look forward to seeing you on Thursday from 10 to 12. It's probably going to be about 10 to 11:30 on Thursday, but we look forward to seeing you on Thursday for the part 2 of the webinar, Contracting in the Green Economy. So on that, Kate, we'll sign off from this end unless you have further comment or questions.
Just check. Do we have any more questions? I thought someone might have had one.
Thanks everybody for giving us opportunity to attend this event. Thank you.
Wonderful. Well, I just want to say thank you to everyone, and we will go ahead and wrap. We are going to put a copy of this recording both up on the YouTube and send it out to everyone. We do have the Thursday session, and I know there's some additional information that will be coming from Energy and Transport Services that we will be able to share out. If you have any questions, write to us at inno.ed@dc.gov. Have a great day, everyone.
Thank you.
All right. Thank you.